Good evening, everyone. Or good afternoon, depending where you are in the world. It's good evening for me. It's just gone 7 p.m. Second time today. Good to see a bunch of people who were here this morning. Back again. All good stuff. But we've got a change of case in this live stream. So mornings lately seem to be dedicated to Sebastian Rogers. But this evening stream is dedicated to Francis C. Gull. Oh, Francis. Will she stay or will she go? I know what I'm betting. I'm betting on her staying because she's a cantankerous old cow. That's what she is. And that's doing cows a disservice. And I shouldn't do that. I like cows. Anyway, there's a 40-page motion for Judge Francis Gull to be either disqualified or to recuse herself. Now, this came out a few days ago, and I've only just got round to doing a live stream on it because the whole thing is 40 pages. So Francis might not have been able to get through 40 pages yet, but I plan to. Now, I haven't actually read this. I've heard it read. I think it was Criminality who read it that I listened to. I've heard it read, but I haven't actually read the words for myself. So hopefully we can get through all 40 pages in one go. If not, then I'll be back tomorrow to do the rest. But I think we'll be able to get through them as long as I don't, dilly-dally too much. I'll rant too much. I'll try not to rant, and then that will be easier. But Purple AJ, before the stream even started, Purple AJ coming through again with 5 more gifted memberships. You are far too kind. And we've got In the Bushes, Norma, Hayes, Cadicia, and Pansy. So you get a month's free membership courtesy of the superstar Purple AJ. Amazing. All right. I'm not going to dilly-dally. I'm going to get straight into it. Dilly-dally ranting, yeah. I do tend to. Has she responded? She kind of has. She's kind of responded, not in a, an order kind of way. She's not done what she did last time, because if you've been following all the pre-trial shenanigans in this case, you'll know that back in January, was it January or February? It's not only the days that are melding into one, it's the weeks and the months as well. But it's back anyway, after Brad and Andy were reinstated on the case. They moved a motion to have Francis recuse herself based on the fact that she was biased against them. But she just brushed that away. She brushed it away and said, denied without hearing. She can't do it this time, though, because they've demanded that she respond with the law. She can't just say denied without hearing. She's got to respond with the law. So she has responded by cancelling the hearings that were due to take place. Well, due to have just finished, actually. 21st through 23rd of May, there was a set 3 days of hearings. And Francis can't do anything. She's had her wings clipped until she gets this sorted. She can't actually, do anything judgy on this case until this is sorted. So she couldn't have held the hearings even if she'd wanted to. Now, the defence had moved to have those hearings moved because of all of the new stuff that's coming out. But Frances had to side with them. For once, she had to side with them, not because she wanted to side with them, not because she thought they were right, but because she can't do anything until this is sorted. So she's had her wings clipped. So she's going to have to respond, and she's going to have to respond with the law. All right. Yeah, hopefully she's just tired of messing with it and takes the easy way out. Well, I don't think she will, honestly. I don't think she will. I hope she will. That would be the right thing for her to do on many different levels. I just don't think she will. I think she's dug her heels in. She doesn't like them. And she's prepared to go the full way. Is Richard Allen in county jail now? He was for the trial. But as the trial was postponed, I do believe Richard Allen has gone back to Wabash. But he was sitting in Allen County Jail for the trial. But I believe he's back at Wabash. All right, so let's get going. Yeah, I agree. Broken Goth doll. His life's over either way. Imagine what it will be like for him if he's acquitted at trial. Imagine what it'll be like for him. There'll be people who will hound him for the rest of his life. And not to, that doesn't even include all the post-traumatic stress disorder that he'll have, having dealt with these guys. It's going to be 2 years. He'll have been in prison for 2 years by the time his trial even comes. So, yeah. All right. Defense, second verified motion to disqualify the judge and request for findings of fact and conclusions of law. So, this is what she has to do. She has to quote the law and the facts. She can't just say, deny without hearing. She has to include the facts backed up by law to explain why she's not recusing herself this time. So all right, so the first section is the legal standard. So I'm gonna skip all the quotations. I'm gonna not read Lucas v. State 249 ins. I'm not going to read all that. We're just going to read the actual words, but it's all there. If you want to go and look up these cases, then be my guest. You can do. So comes now the accused Richard M. Allen by attorneys Rosie and Baldwin, and pursuant to Rule 2.4 of the Indiana Rules of Criminal Procedure and the Indiana Code of Judicial Conduct, moved for a change of judge from Judge Frances C. Gull or her recusal from this cause. In support of said motion, Richard M. Allen swears and affirms the following. Legal standard. The filing of a motion for disqualification and or request for recusal strips the court of jurisdiction to decide on any matters until a ruling on the disqualification motion occurs. So that's what I've just been saying. That she can't do anything. She's stripped. She's stripped bare. Her wings clipped until this is dealt with. So pursuant to Indiana Rule of Procedure 2.4b, the state or defendant may request a change of venue from the judge only for bias or prejudice. The motion must be accompanied by an affidavit signed by the defendant or prosecuting attorney. The affidavit must set forth facts and reasons for the belief that bias or prejudice exists. If the defendant signs the affidavit, which he has, the defendant's attorney must file a certification that the attorney believes in good faith the facts recited in the affidavit are true. The court must grant the request if the facts recited in the affidavit support a rational inference of bias or prejudice. Put another way, the facts contained in the affidavit must show there is a reasonable basis to question the judge's impartiality towards Richard Allen and his defense team. So I can't see that you can look at it in any other way. I can't see how you can think that Francis has been a fair judge so far. And, you know, woe betide the defence if she's still here at the trial. It's just going to be an absolute shit show. It's just going to be a circus. It really is. You know, you kind of think judges do tend to side against the defence at trial, but just imagine what it's going to be like. And all done behind closed doors. None of us will be able to see all of that injustice. None of us will be able to see. It's essentially behind closed doors because the journalists can't even take phones in. They can't even tweet while they're in there. So it's just going to be what the news can put together, you know, after the fact. So, okay. So this rule 2.11 of the Indiana Code of Jurisdictional Conduct requires a judge to disqualify him or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action. The rule on disqualification and the canon on recusal both adapt a threshold of reasonableness, i.e., would an objective person have a reasonable basis for doubting the judge's impartiality? Well, I do. You might consider me biased because everything that's happened to Richard Allen over the last however many months it is, 19 months now, is it? Yeah, it is 19 months that he's been in prison, whether or not he's guilty. And I am on the fence. I want to see the evidence. But the way he's been treated, I no longer consider myself objective in this case. And I want her gone. So if you can be objective, if you are objective, then what does it look like to you? I guess I'm asking. Kindness Cake, thank you for the £4.99. That's very kind of you. Thank you so much. Thank you. All right. The comments to Rule 2.11 of the Indiana Code of Judicial Conduct provide additional guidance. Under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions in paragraph A1 through 6 apply. In many jurisdictions, the term recusal, is used interchangeably with the term disqualification. The judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Interesting. A judge must disclose on the record information that the judge believes the parties or the lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. The test under the canon is whether an objective person knowledgeable of all the circumstances would have a reasonable basis for doubting the judge's impartiality. The question is not whether the judge's impartiality is impaired, in fact, but whether there exists a reasonable basis for questioning the judge's impartiality. And I think there is a very strong and reasonable basis for questioning her impartiality. Whether or not she's meant to be, which I believe she has meant to be, I think there is a lot of questions here. So, this legal standard is not lofty. The accused has a federal due process right to an unbiased judge under the 5th and 14th Amendment of the US Constitution. Judicial bias is one of the narrow classes of constitutional violations that implicate structural error. Cases of judicial bias involve a denial of the most fundamental constituent constituents of due process, so fundamental that a conviction in their absence is indecent, even if the defendant is plainly guilty. Structural errors render a criminal trial fundamentally unfair and are not subject to a harmless error analysis. The preamble to the Code of Judicial Conduct provides that judges should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. None of which, I believe, Francis is displaying here, or has done from the outset. She's just none of those things. Okay. So, Richard Allen incorporates his first verified motion to disqualify, filed January 28th. Yeah, you see, I was good. I thought it was January, or maybe early February. As if fully set out herein. So this is incorporating their motion to disqualify from January. They've just bulked it up. They've bulked it up. And also what they didn't do in January was hit her with the law. Like they did, they just stated all the facts that they believed showed her bias. But now she has to respond with the law. So she can't just say denied without hearing. She has to actually explain why. All right, so after the Supreme Court quickly reinstated the defence following oral arguments, that seems so long ago now, doesn't it? That seems so long ago when we all sat here watching the Supreme Court. Anyway, on the same day, the Indiana Supreme Court did not grant Allen's request for Judge Gull to be recused, based upon the limited record set out at the time by Allen's appellant counsel. On January 28, 2024, the defence filed its motion requesting Judge Gull be disqualified, knowing that the Indiana Supreme Court was not aware of all the reasons Allen could cite that showed a rational inference of bias. The defence cited 18 reasons for Judge Gull to recuse herself in that January 28th motion. Then, on February 6th, before finding out exactly why the Indiana Supreme Court rejected Allen's request to have her removed, Judge Gull denied the defence request for her to be removed. And we've got a footnote here. The Indiana Supreme Court's opinion detailing the reasoning for not taking Judge Gull off the case was issued on February 8th and certified on February 15th. Okay. Judge Gull's one-sentence denial of the defence motion to have her disqualified stated, the court, having defendant's verified motion to disqualify, filed January 28th, defendant's affidavit filed January 28th, and certification of Richard Allen's attorneys filed January 28th, under advisement and having considered the pleadings, now denies the verified motion to disqualify without hearing. That's actually more than she normally writes. Normally, it's just denied without hearing. I might get a t-shirt printed, denied without hearing, and send it to her. She can wear it under her robe when she's doing her judging. Denied without hearing. All right. As the Indiana Supreme Court unanimously denied defendant's previous request. So she said, well, because the Supreme Court didn't say I had to recuse myself, then it's denied without hearing. That was her get out clause that time, but she's not got that this time. She's not got that. Had Judge Gull waited only 2 more days before ruling on the defence motion to have her disqualified, she would have had the benefit of learning exactly why the Indiana Supreme Court did not disqualify Judge Gull. I think she got a heads up. That the ruling was going to come out, and she slipped that in before the ruling came out. I don't know though. I don't know that. On page 16 of its order, reinstating Baldwin and Rosie, the Indiana Supreme Court stated that Allen, through his attorneys, did not identify anything that she had done that demonstrates she isn't impartial. Okay. At the time the Indiana Supreme Court issued its opinion, the court did not have the benefit of reviewing the 18 reasons the defense cited in its January 28, 2024 filing, which the defense claimed supported a showing of Judge Gull's bias. Certainly, some of those 18 reasons were included in the Indiana Supreme Court's opinion as, by themselves, not being enough to cause Judge Gull's recusal. However, many of the examples of bias identified by the defense in its January 28th motion were not cited by Allen's lawyers in their request for Judge Gull to recuse herself. In other words, Judge Gull's use of the January 18th, 2024 Supreme Court ruling as a sort of blanket immunity to support her decision not to disqualify herself was wrong, in that the Indiana Supreme Court's February 8th opinion, leaving Judge Gull on the case, was clearly based on a very finite set of reasons argued by Allen's appellant attorneys, and not the longer list of reasons articulated by Baldwin and Rosie in their motion to have Judge Gull disqualified. So in January, Judge Gull ignored that longer list and instead erroneously used the Indiana Supreme Court ruling as her reason to remain on the case without any legal analysis and before reading the Indiana Supreme Court opinion. So all good so far. They're setting all this out nicely. The defense is requesting that if Judge Gull does anything but recuse herself from this case, that she issue findings of fact and conclusions of law that support her decision to deny the defense motion, rather than a one-sentence order summarily denying Richard Allen's request, something that she does so often, denied without hearing. In addition to the reasons cited in his January 28th, 2024 motion, Judge Gull has revealed a rational inference of bias towards the defense based on the following. Judge Gull engaged in ex parte communications with the state of Indiana. That in itself is enough. That in itself, if they can prove that she's had little secret conversations with Slicky, that's enough. That's enough to show bias. She can't do that. And I believe she must have been. I believe she has been all along. But the thing is proving it. Judge Gull interfered with a properly subpoenaed defense witness. She did. She absolutely did. Robert Baston from Westville. She said just because he didn't want to come out of his cell and attend the hearing that he'd been subpoenaed for, she said, oh, it's okay, leave him. It's okay, leave him. If he'd been a prosecution witness, she'd have forced him under that subpoena to attend. He didn't want to attend because he knew it would be worse for him when he got back there. And he was probably right. But he was subpoenaed. So legally, he should have been made to go. Judge Gull treats the prosecution more favourably than the defence. I can't argue with that in any way, shape or form. Judge Gull engaged in the act of prosecuting Richard Allen by inviting a prosecutor to file pre-trial motions seeking the limitation of evidence of third-party culpability and also forecasting the outcome of such a request by the state. Yes. Judge Gull continues to make disparaging comments about the defence counsel in open court and in orders issued by the court. She does. She calls them sloppy. If that's a legal term, then I'll take that back. I'm not a lawyer. So just because I've not been to law school, there may be the word sloppy somewhere in a legal, I don't know, a legal act somewhere. I don't think so, though. Judge Gull's handling of defence pleadings versus her handling of prosecution pleadings. Judge Gull placed blame on defence counsel and its staff for administrative failures in maintaining confidentiality of ex parte defence filings, whereas evidence revealed that failures were on the court side of the filings. Never admit that, would she? Judge Gull failed to conduct her own internal investigation into allegations of leaks coming from her own staff, while facilitating contempt proceedings against Richard Allen's chosen attorneys for leaking confidential information related to this case. And look, let's be clear, it wasn't the defence that leaked anything. It wasn't. They didn't leak anything. Judge Gull effectively denied Richard Allen his right to a speedy trial by not requiring the prosecution to follow the same restrictions at trial as she was forcing the defence to follow, which forced the defence to seek a continuance of the May 13th, 2024 speedy trial date. All right, so we're going to go into some details now. So are you ready? Are you ready? Get your popcorn. Exactly. She's supposed to uphold the law in the courtroom to treat both sides fairly. Yeah, she holds the scales of justice, and the scales of justice must be balanced. Get your seatbelts on. Ex parte communications and interfering with defence witnesses. Judge Gull participated in ex parte communications with the state of Indiana through its witnesses to the detriment of the defence. On April 5th, 2023, Richard Allen, by counsel, filed his emergency motion to modify safekeeping order based on the conditions of his confinement at Westville Correctional Unit. On April 14th, 2023, Judge Gull entered an order stating the Indiana Department of Corrections was authorized to move the defendant within the Department of Corrections to accommodate his medical and physical needs pursuant to medical directives by DOC physicians, psychiatrists, and psychologists. All right. On May 4th, 2023, Mr. Allen, by counsel, filed his motion to reconsider and request for due process hearing, which the court set for June 15th, 2023. In preparation for the hearing, the defence served a valid subpoena on witness and Westville inmate Robert Baston to appear at the hearing, June 15th. When a deputy from the Carroll County Sheriff's Department went to the Westville Correctional Unit on June 14th to transport the inmate to the hearing, the inmate became uncooperative. Carroll County Chief Deputy Tobe Leesenby contacted Judge Gull about the situation, and Judge Gull told Deputy Leesenby to leave the inmate there, as he did not want to come to the hearing. Tobe Leesenby was the first witness called by the prosecution at the June 15th hearing, and certainly will be called as a witness at trial. Yet Judge Gull and her staff communicated with this prosecution witness the day before his testimony without the full disclosure of said communications to the defence. Yet they had no idea. They had no idea that their witness wasn't going to come, and that the judges said, oh, it's okay. It's okay. Additionally, Tony Liggett, who was a witness at the June 15th and will be a witness when the trial matter goes to trial, issued a report in which he states, on the 14th day of June 2023, communication with the court was established by Sheriff's Major Chief Deputy Tobe Leesenby, wherein Major Leesenby was advised by the court to disregard any further efforts to retrieve inmate Baston from Westville. And this is just what they can prove. That's in writing. They can prove that. But she's been doing this all along. Right? How did, when that day, you know, when all the cameras were there, on October 31st, 2023, and she allowed the cameras in for her great showdown that she was going to, you know, disqualify the attorneys live, you know, live streaming to the world, and it didn't quite work out for her that way. However, how did Slick Nick McClellan know to bring a bunch of witnesses with him. All those cops who turned up as witnesses, like Doug Carter and Liggett and all of them, all turned up. How did they know to turn up for that hearing? Because it wasn't billed as a disqualification hearing. The defense had no idea that this was a disqualification hearing. In fact, if you read the paperwork back, Rosie had actually asked what this was about. And they were just told to report to her chambers. It wasn't the June 1st. It wasn't October 31st. I think it was October 19th. I can't remember now, but anyway, it was the one. It was the one where she let the cameras in, and she'd had this pre-prepared statement that she was going to read to them in court. And Nick brought a bunch of witnesses to say how incompetent the defense was. How did Nick know? How did all those guys know to turn up if there wasn't ex parte communications between Judge Gull, Slick Nick, and all of those witnesses? But they'd have to prove that. This one they can prove. On June 14th, Judge Gull sent an email to the party stating, FYI, the Carroll County Sheriff's Transport Officer went to Westville to pick up the inmate requested by the defence team per subpoena. The inmate refused to come out of his cell and demonstrated an ability to fight if forced. The transport officer stood down and had left the facility to return to Carroll County without said inmate. I have asked for a formal written report on these activities, which will provide to you upon receipt. What Judge Gull failed to tell the defence in that email, what Judge Gull failed to tell the defence in that email is that she was the person who used her authority as judge to direct the Carroll County Sheriff's Department to ignore a valid subpoena of a defence witness scheduled to testify at an impartial hearing on behalf of the defence. It's not unusual for those incarcerated not to cooperate when being transferred from one facility to another when presented with a subpoena. Judge Gull has detailed on more than one occasion her vast experience on the bench. It would be surprising if this situation had not occurred in her tenure. Yeah. However, the lack of cooperation of an inmate is not a legal justification for a judge to direct the IDOC or a county sheriff's transporter officer to simply ignore a valid subpoena. The proper method for a judge facing this situation would be to not communicate in an ex parte fashion with witnesses who are involved in the case. Rather, it would be to contact the attorneys of both parties, prosecution and defence, explaining that the court has been informed that there is a potential problem with the transportation of a witness from the IDOC, and that the court will not talk to the state of Indiana without talking to both sides. Then, after both sides are engaged, to work on a solution. If the defence still wanted the witness to attend the hearing, then law enforcement would still be required to use whatever means necessary to transport the inmate, unless the state of Indiana filed a motion to quash the subpoena, which was granted by the court. This is as messy as King Charles III's royal portrait. Oh dear. She is used to getting her own way. She is. That's the problem. She's probably never been challenged like this before. Or maybe she has and she got away with it. I don't know. Anyway, after the June 15th hearing, Judge Gull denied Mr. Allen's motion to reconsider, stating, the evidence presented demonstrated at the hearing on defendant's motion to reconsider did not support many of the allegations advanced by defendant's counsel. In fact, the evidence presented demonstrated that the defendant is treated more favourably than other inmates housed at the Westville Correctional Facility. This is disingenuous given that Judge Gull prevented the defence from presenting the very evidence that she was lacking. Any perception of Judge Gull's bias was supplanted with proof of actual bias when Judge Gull denied Mr. Allen's motion to reconsider, claiming a lack of evidence, when she prevented Mr. Allen from presenting the testimony of Mr. Baston. As if, like, the warden stands up and say, oh, yeah, everything's great, everything's hunky-dory, it's like a holiday camp. And then she went, oh, okay then. He can stay where he is at his holiday camp. Communicating with state's witnesses in an ex parte fashion provides a rational inference of bias. Oh, dear. Issuing a directive for the state's witness, Carroll County Sheriff, to ignore a valid subpoena to the detriment of the defence provides a rational inference of bias. Absolutely it does. Judge Gull's failure to fully inform the defence of her involvement in directing law enforcement to ignore a properly issued defence subpoena demonstrates deception. Such deception to the defence provides a rational inference of bias against the defence. Okay. Recent ex parte communications and additional evidence of Judge Gull's favourable treatment to the state of Indiana as opposed to her treatment of Richard Allen and his defence team. All right. We have more. And we don't know this. I don't think we know this anyway. On May the 3rd, 2024, the defence counsel deposed Sheriff Tony Liggett. During this deposition, it was learned that the court had engaged in activities with law enforcement and prison representatives regarding Richard Allen's housing, both during scheduled jury selection in Fort Wayne and during the scheduled jury trial in Carroll County, Indiana. The court failed to communicate any of these plans to the defence in advance of the court's actions. Again, the court appears to have engaged in ex parte communications with the state of Indiana. I wonder what all that's about. It must have been regarding Richard Allen's transport. Like that he was just moved to Allen County Jail and then moved back again. It must be that. They must have just moved him without letting the defence know. I don't know. Hopefully they're going to tell us in the preceding paragraphs. At the June 15th, 2023 hearing concerning the pre-trial housing of Richard Allen, Sheriff Liggett claimed that the only reason he objected moving Richard Allen to the Cass County Jail, approximately 25 minutes from Delphi, was due to lack of manpower to transport Richard Allen to and from jail. So let me get this straight. They can't do a 25-minute there and a 25-minute back journey from Cass County to Carroll County, but they can do a several hours journey from Westville and now from Wabash, because Liggett goes and picks him up. So how does that work? Like Wabash is like, I don't know, it's 2 or 3 hours away from Carroll County. So would you rather do a 2-hour to 3-hour journey or a 25-minute journey? Which would you rather do? Which is most cost effective? Okay. During his May 3rd deposition, Sheriff Liggett acknowledged that Richard Allen was set to be housed at the Tippecanoe County Jail during the scheduled jury trial, and that the transportation of Richard Allen to and from the courthouse was arranged. Therefore, there's no need to continue to house Richard Allen at the prison some 2.5 hours from Carroll County during the pendency of this case. So he was meant to be going to Tippecanoe County Jail, which the defence didn't know about, but he ended up in Allen County Jail. It's not mathing. Exactly, Terry. It's not mathing. The math ain't mathing. It's not. We've got a maths problem here. All right. According to Sheriff Liggett, Judge Gull was aware of these circumstances. Despite this, Judge Gull failed to communicate or even inquire with the defence about Richard Allen's housing circumstances. It's their guy. It's their client. Surely they'd be the first people that would need communicating with if Richard Allen was going to be moved. Like, you know, hey, you guys, we need to move Richard Allen like closer during the trial, because we can't have him doing a 2.5 hour journey there and a 2.5 hour journey back every day to and from trial. I mean, that would be exhausting for all concerned. So we're gonna put him in one of the county jails nearer. And, you know, we've got Tippecanoe County Jail that can house him. We've got this jail that can house him. Well, if Tippecanoe County Jail can house him and, you know, and keep him safe, or Allen County Jail can keep him safe during the trial, well, why are they not able to keep him safe for the rest of the time? Why does he have to be in a maximum security prison hours and hours and hours away from his family and from his defence team? Make it make sense. Okay. It's also true that despite alternative detention options, Judge Gull has failed to intervene and protect Richard Allen, who is at this moment in time presumed innocent, from his appalling confinement conditions by facilitating a more suitable pre-trial housing arrangement for Richard Allen while he awaits trial. Judge Gull's actions of ignoring the defence in matters relating to the housing of their client, while continuing to communicate with the state of Indiana in an ex parte manner, provides a rational inference of bias against Richard Allen and his defence team. Too right it does. And that's just the tip of the iceberg. That's just what they can prove. 3 hours and 48 minutes from Wabash to Allen County. Wow. But it's Carroll County, like the trial would be in Carroll County. The jury selection was going to be in Allen County, but the actual trial itself was going to be in Carroll County. So I'm assuming that they were going to house him in Allen County Jail for the jury selection and then move him to Carroll County Jail for the trial. That would kind of make sense. Okay. Judge Gull invited the prosecution to seek limitations on Richard Allen's Sixth Amendment right to prove that other parties committed the crimes in question. Both Judge Gull and the prosecution have known since the filing of the first Franks notice, which I don't think that Gull has ever read, because it was 136 pages. She's struggling reading 40 pages that we're currently reading. So I do not believe that she's read that Franks notice. I do not believe she's read it. Anyhow, 2 hours and 39 minutes to Carroll County. Yeah, so can't be doing that on a daily basis. But every time Richard Allen has to be transported, that's where they're transporting him from. So if Tony Liggett thinks that 25 minutes away is too much, then how has he been coping with a 2 hour and 39 minutes of a journey? How's he been coping with that? All right. Okay, both Judge Gull and the prosecution have known since the filing of the first Franks notice on September 18th, 2023, that the defence will be relying on a third-party suspect defence. In rebuttal to the defence's theory regarding third-party perpetrators, the prosecution listed an Odinist expert on their supplemental witness list emailed to the defence on March 17th. I noticed that. Yeah, so prosecution has got their own Odinism expert, you know, ready to rebut whatever the defence comes up with. At no time between September 18th and April 27th did the prosecution take any action to prevent the defence from pursuing a third-party perpetrator defence. During this time, the defence conducted many depositions related to their third-party perpetrator defence, and in addition made numerous requests to the state seeking additional discovery regarding third-party suspects. On April 28, 2024, Judge Gull directed an email to both the prosecution and defence regarding scheduling matters, and without any prompting, informed the defence that she, Judge Gull, was fully aware of the law regarding third-party perpetrator defences and would be prohibiting the admission of such evidence by the defence unless some nexus between the two could be proven. Okay. This unprompted comment was akin to an invitation by Judge Gull to the prosecution to file a motion in limine that would prevent the defence from presenting evidence that third-party suspects committed the murders. She's in on it. I'm telling you, she's in on it. If anybody's been able to dig up any dirt on Judge Gull, I am all ears, because I can't find anything. I can't find any links between her and anybody who might be moving in ordinary circles. She's obviously keeping everything very close to her vest and under her robes, hidden in her plumage. But she's in on it. I'm telling you, she's in on it. All right, approximately 12 hours later, at midnight on a Sunday night, the prosecution filed its motion in limine requesting that Judge Gull not allow the defence to discuss third-party suspects. The court's invitation to the prosecution to seek such limitations creates a rational inference of bias in favour of the state of Indiana and against the defence. Listen, for those of you watching the Karen Reid trial, how on earth would Judge Gull have coped with Andrew Jackson and David Yannetti? How would she have coped with them? Because they're immense. Their third-party guilt defence is immense. The amount of work they've done parallels the amount of work that these guys have done for Richard Allen. And I firmly believe that Karen Reid is innocent. And at the moment, Lally is putting up a really bad defense. And he's the prosecutor. So these third-party guilt defenses do work if there indeed is third-party guilt. So you can imagine that, little Nicky boy is shitting his pants every time he thinks about it. Alan Jackson, what did I say? Did I say Andrew? I said Andrew Jackson, didn't I? Was he a president? Andrew Jackson? I know there's an Andrew. I'm thinking of Andrew Baldwin, but anyway, Alan Jackson. It's confusing, all these names. All right, so yeah, you're not even what Nick proposed was that the defense were not even allowed to utter the names Brad Holder, Patrick Westfall, Elvis Fields, Odin. they weren't even allowed to utter the names of them. Never mind, put up a defense. Now, she hasn't ruled on that as far as I can tell, but still, she opened the door for it. All right. Judge Gull has repeatedly disparaged Richard Allen's appointed public defenders. Beginning October 19th, Judge Gull began verbalising her negative feelings towards Richard Allen's defence team using words such as grossly negligent and incompetent. When Richard Allen's original defence team attempted to enter their appearance for Richard Allen pro bono, Judge Gull would not allow their appearance to be entered based upon her view that the defence attorneys were grossly negligent and that Richard Allen could not even expect an adequate defence from attorneys Baldwin and Rosie. Yeah, so it was October 19th when the world was welcomed in to Allen's Superior Court, and all the cameras were waiting. And she, she tried to ambush them, but they didn't play ball. And then it was October 31st at the hearing that she actually disqualified them. Now, she didn't allow cameras in. They both entered pro bono appearances, so she basically had to disqualify them all over again. But we've got the transcript for that, but we haven't got cameras weren't allowed in. All right, so that was the timeline. There's a footnote there. Oh dear, there's a long footnote here. All right. Judge Gull stated the following to Richard Allen at October 31st. Mr. Allen, I understand you wish to have Mr. Baldwin and Mr. Rosie represent you in this matter. I have grave concerns, Mr. Allen, about their representation of you. The previous findings by this court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know you want. I know what you want. You've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns I've had with the gross negligence that I have found. She didn't find anything. She just said it. She didn't find anything because there was actually no hearing on it. In her comments at the October 31st hearing, Judge Gull stated the following: I cannot and will not allow these attorneys to represent you with the concerns I've had with the gross negligence that I have found. These words alone equate to outright bias on the part of Judge Gull towards the defense and towards Richard Allen. Surely people should be able to see that. Even if you think that Rosie and Baldwin are the worst attorneys in the world, you cannot deny, you absolutely cannot deny that she's biased. She's biased. If Richard Allen wants those attorneys, and at that time on October 31st, they were willing to represent him pro bono, there is no way that she should have stood in their way. That is an out-and-out bias. We've all been saying that. Surely you can see that. Even if you think Richard Allen is guilty, it doesn't matter whether you think he's guilty or innocent or you're on the fence like me. It doesn't matter. You surely have to be able to see the bias there. All right. Since denying the defence motion to disqualify, Judge Gull has continued to show her bias in a variety of ways, including demeaning Richard Allen's two defence lawyers, who have been, between them, over 50 years of experience and zero findings that they are incompetent or have violated the professional rules of conduct. Most recently, in her April 30th, 2024, two-page order detailing her ruling on the prosecution's request to find the defence attorneys in contempt, Judge Gull continued her maligning of the defence by calling them incompetent, negligent and sloppy in the way that they handled evidence. Yes, she did. She called them sloppy. Great legal term, that. Furthermore, in that same order, Judge Gull articulated to not only the lawyers, but to the general public that she would be referring her findings to the Office of Judicial and Attorney Regulation. Judge Gull's targeted comments and reference it to the Office of Judicial and Attorney Regulations have no legal relevance to her findings of non-contempt and appear to have been intended only to further disparage the character and fitness of defence attorneys Rosie and Baldwin. While Judge Gull has on at least 8 occasions denied defence motions with 3 words, denied without hearing. Is it only 8 times? It seems like more. It seems like them all, but I've not been counting. Judge Gull felt it necessary to use insulting language concerning defence counsel only 2 weeks before the beginning of trial. The fact that Judge Gull continues to disparage the character and fitness of defence counsel when she could have otherwise remained silent on the matter provides a rational inference of bias against the defence. Totally. Other examples of Judge Gull treating the prosecution more favourably than the defence. At the March 18th contempt hearing, the defence provided evidence to the court that the Carroll County prosecutor, Nicholas McClelland, interacted with a social media content provider named Gary Baudet, aka Fig. So Fig, what's his name on YouTube? Fig Solves, is it? Fig Solves? The evidence was in the form of emails, including an email in which Fig claimed that McClelland had requested Fig to erase their communications. The defence provided evidence that other leaks occurred over the case's history, implying that those leaks could have emanated from McClelland's office. Where did Barbara MacDonald get the Odin report from? She sat on Court TV in September of 2023 with the Odin report in front of her. Rosie recognised it. Like, as the camera panned towards her, you could see the actual pages as she was flicking through them. And it's like, that's the Odin report. How did she, a reporter for Court TV, get her hands on discovery materials? That's discovery materials. Isn't discovery materials meant to be, you know, included in the gag order and the protection order? How on earth has she been able to sit on Court TV in front of Vinnie Politan and the world's media? How has she been able to sit with a report included in the discovery and no one has bothered to check? How has that happened? In December of 2022, that dude, what's his name? My name's escaping. The one who's written a book. Oh, God, I can't remember his name now. But he claimed to have the crime scene photos in December of 2022. Now, whether he had all the crime scene photos or just like select ones, but he seemed to know far more about the crime scene than had been released. How is that even possible? Yeah, Barbara McDonald has got special friends. Yeah, she might have. But how did she get the Odin report? Which special friend gave her the Odin report? And don't even get me started about Murder Sheet. Don't get me started about Murder Sheet. How come none of them were called as witnesses? I want to see Barbara MacDonald subpoenaed and under oath explain where she got, thank you, Chris Todd, thank you, where she got the Odin report from. The Todd guy, I want to know what he knew about the crime scene photos in December of 2022. I want to know all of these things. I want to know how people got their hands on protected materials. All right. Where are we at? All right. The defense provided evidence that other leaks occurred over the case's history, implying that those leaks could have emanated from McClelland's office. While Judge Gull required the defense to cooperate in the investigation of leaks attributed to the defense, Judge Gull seemingly had no interest in similar allegations attributable to the prosecution. Judge Gull's actions, as referenced in the various paragraphs above, create a rational inference of bias against the defense and in favor of the prosecution. What do we think about this psychologist? What's her name? Monica Waller. Monica Waller, who was, she's one of the prosecution witnesses who claims that Richard Allen, during her confidential meetings with him, all right, this is the psychologist at Westville, Monica Waller, has been, tending to Richard Allen and his mental health needs. And Monica Waller claims that she has heard incriminating statements from Richard Allen. So I've got a problem with the fact that he believes that anything that he says to his psychologist is therapy and he's not being taken down to use against him in a court of law. However, maybe that's just a little bit naive of me because, you know, I don't know. But she was in a whole bunch of Facebook groups. Once she was deposed by the defence, guess what? On the very same day, she went and left a whole bunch of Delphi-related Facebook groups. Now, people have said to me that it's a different Monica Waller. Well, how many Monica Wallers are there in Indiana who are psychologists? How many of them are there? Because it doesn't seem to be a terribly common name. And I don't believe it was a different person. Anyhow, I digress. Judge Gull treated the defence team differently than she treated her own office regarding allegations of confidentiality discovery matters. At the March 18th contempt hearing, the defence tendered evidence to Judge Gull that showed that her staff may have leaked confidential information to social media sources. The evidence included emails and videos from a content provider named Fig and others, as well as testimony from other witnesses. In an October 2022, start again, Michelle. In a November 22, 2022, social media video tendered to the court, Fig detailed sensitive crime scene information that at the time was not available to the public. Footnote. The defence attempted to admit Exhibit Q, which was a flash drive containing a YouTube video from November 2022 in which Fig announced his knowledge of a bullet purportedly found at the scene. So nobody knew about the bullet, the magic bullet, until the PCA came out. Yeah, the state psychologist in a bunch of Facebook groups. Like there was one Facebook group, I'm not in any Delphi Facebook groups, but something like Delphi gossip or something. I mean, you know, she's in all these. I mean, look, if you wanted to, you know, be a snitch for the state, surely you're not gonna be in Facebook groups under your actual name. Why wouldn't you like create a new Facebook account with a different name? I mean, how stupid you have to be the state psychologist working in the state prison, and you're going to be called as a prosecution witness, and you sat there in all these Facebook groups with your actual real legal name. What an absolute clown. Anyhow, okay, so nobody knew about the magic bullet until the PCA came out. There's only one Monica Waller registered with the board in Indiana. Yeah. FB profile was friends with people who worked at Westville. I know this. But people have come along to me and said it's a different Monica Waller. All right. Okay. Whatever. Who just happened to leave a bunch of Facebook groups on the very day that the other Monica Waller was deposed. Come on now. No chance. All right. So this this YouTube video knew about the magic bullet before any else of us did. The judge refused to admit said document as part of her analysis for contempt, but it was accepted as part of the record for appellant purposes. Good. This flash drive is still available to Judge Gull if she becomes concerned that either McClelland or someone in her office was leaking information to Gary Fig Baudet. Okay. Is that video still up? Shall we go and watch it? Okay. Where are we at? Where are we at? That's 5. Where's 4? I'm lost. All right, we'll start here. Oh, there it is. All right. So at the time, Fig detailed his knowledge of crime scene information That information was in the possession of the court. The defence then attempted to provide emails and did provide testimony to the court in which a witness, Stephen Wood, testified that Fig told him, Stephen Wood, that his source of that confidential and sealed information was someone on Judge Gull's staff. So that's record of proceedings on the hearing. Judge Gull has shown no concern. Do you know what? It wouldn't surprise me if it wasn't Judge Gull herself. It wouldn't surprise me. Am I shouting? I'm shouting. I'll move the microphone back. It wouldn't surprise me if it wasn't Gull herself. Mind you, she's willing to throw her court staff under the bus anyway. So, you know, even if it was her, she'd probably blame them. Judge Gull has showed no concern whatsoever about unmistakable evidence that on November 22, 2022, Gary Fig Baudette revealed sensitive crime scene information at the time when that information was not known by the public, later claiming that he, Fig, received said sealed information from Judge Gull's staff. Judge Gull has called the defence incompetent, negligent, grossly negligent and sloppy concerning the very same allegations against her staff that Judge Gull has apparently refused to investigate. And what they did, the defence, is way different. There was no intentional leaking from their side. One of them was an email that Andrew Baldwin addressed to the wrong person, accidentally sent it to Brandon Woodhouse rather than Brad Rosie. We've all done it. We've all done it. And you email them back saying, I'm really sorry, just can you delete that email? It's not for you, please delete. And end of the matter. And then the other one was Mitch Westerman, who Andy Baldwin thought was a friend, who used to work in Andy Baldwin's office for 7 years, who got a new job in ethics, of all things. So why wouldn't he trust Mitch Westerman, who he knew, he'd known for 10 years and worked with for 7? Why wouldn't you trust him? You wouldn't think that somebody like that would go and betray you, but he did. So none of what Andrew Baldwin did was intentional. What these guys are doing is very intentional. These are intentional leakages. Anyhow, the defence has no idea whether Judge Gull's court staff leaked sensitive information to a social media site, but there does exist facts to support this allegation. Despite these facts, the defence is aware of no action taken by Judge Gull to investigate these circumstances. This is a stark contrast from the actions of Judge Gull, who in the fall of 2023 endorsed the prosecution and its law enforcement personnel in seeking out suspects associated with the leak of crime scene photos to the public. The fact that Judge Gull has treated the defence differently when the defence is accused of a leak and has treated her own staff or the prosecution creates a rational inference of bias. Well, that's at the very least. At the very least. Judge Gull wrongly blamed the defence for ex parte filings, which were inadvertently directed to the prosecutor. Okay. The defence learnt from a prosecution filing that the prosecution had somehow received Mr. Allen's ex parte documents that were not to be viewed by the prosecutor. Oh, yeah, remember this. Yeah, it says ex parte on it in big letters. And it seems that, the Delphi prosecutor, Carroll County prosecutor, doesn't understand the term ex parte. Like for one party, not for you. But no. The defence learned from prosecution filing that the prosecution had somehow received Mr. Allen's ex parte documents that were not to be viewed by the prosecutor. Upon inspecting how this happened, the defence determined that Judge Gull's staff, or the Carroll County clerk, errantly misdirected these documents to the prosecutor, which he still shouldn't have read. Even if it was, sent to him, he shouldn't have read it because it says ex parte on it. When the defence counsel staff reached out to Judge Gull's staff to determine why and how multiple ex parte motions had been sent to the prosecutor, Judge Gull, without investigating the matter, fired off an email to the defence disparaging its staff and placing the blame on the defence. Unbelievable. Unfreaking believable. Having been accused by Judge Gull of making the mistake, the defence staff who filed the ex parte motions then reached out to the docs pop. What's the docs pop? But anyway, reached out to docs pop to make sure that she was filing the ex parte motions correctly. It was determined that the defence was filing the motion correctly. The entity responsible for sending the ex parte documents to the prosecution, therefore, was either Judge Gull's staff or the Carroll County Clerk. Attorney Rosie then reached out to the Carroll County Clerk, who maintained that she had correctly handled the ex parte documents. The defence, in the possession of screenshots which prove that defence counsel staff filed the ex parte matter confidentially, and that proves that the defence staff provided services only to attorneys Rosie and Baldwin, not McClelland or any other person. This is the proof that the defence staff followed the rules for filing ex parte motions. The defence did not send out the ex parte motions to McClelland, in spite of Gull's quick accusation. Judge Gull failed to investigate how such a significant error could have been made to avoid misdirected ex parte filings in the future, but rather simply blamed it on the defence. Judge Gull's reaction in blaming the defence, you guessed it, when the link appeared to have emanated from Judge Gull's own staff, shows a rational inference of bias. Accusations of violating rules on access to court records. It just goes on and on and on. It just goes on and on. Due to the way Judge Gull maintains the records on the case, attorneys Margaret Smith and Cara Weinecke entered their appearances and filed a petition for writ of mandamus and prohibition. Following Smith and Weinecke's original action for writ of mandamus, Judge Gull hired a lawyer and then was forced to cure most of the issues that Smith and Weinecke identified prior to the hearing in the Indiana Supreme Court. In other words, Judge Gull and her attorneys recognised that she had errantly violated the rules on access to records and then cured those errors. Calling the defence incompetent, grossly negligent and sloppy, while ignoring the fact that both the court and the prosecution have been accused by others of behaviour that might or would be considered incompetent, grossly negligent or sloppy, provides a rational inference of bias. Yeah, all those records that on that drive, it's like she just made a Google Drive, to put these documents on. It's like nuts. It's crazy. It's like a bad crime novel. No one would believe it. No one would believe it. It's just nuts. All right, defence motions are treated differently than those of the prosecution. While at least 5 outstanding defence motions were pending related to the merits of the case, all that needed to be ruled on as soon as possible for purposes of trial preparation for the defence, Judge Gull chose not to issue orders or set hearings on any of those motions. Instead, Judge Gull chose to spend valuable court time setting a half-day hearing on the prosecution's motion for contempt. The prosecution's motion for contempt did not address the merits of the murder allegations against Richard Allen, nor was the contempt motion a time-sensitive matter. There is no reason that the contempt hearing could not have taken place after Mr. Allen's trial, or not at all, because there was no contempt. The prosecutor filed his motion for contempt against the defence on January 29th. 3 days later, February 1st, Judge Gull issued an order setting the matter for hearing. The defence has never received such a quick setting on any of their motions. Well, yeah, and when she does rule on them, it's denied without hearing. Even at this moment, several outstanding motions have yet to be ruled on. For example, the record shows that on more recent pleadings filed by the parties, Judge Gull quickly prioritised the prosecution's request for contempt over the following defence motions. Motion to suppress confessions. The defence filed this motion on April 11th, 2024, but it was ignored by the court until the recent May the 7th hearing. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for a hearing only 2 weeks later, while Judge Gull failed to even acknowledge the defence motions for suppression of the confessions for nearly a month, and then only did so at a hearing. Motion to suppress the accused's second statement. The defence filed this motion on April 15th, 2024, but it was ignored by the court until the recent May 7th hearing. Again, it took Judge Gull only 3 days to file the written order addressing the prosecution's motion for contempt, and then setting it for 2 weeks. 2 weeks later, failed to even acknowledge the defence motion for over 3 weeks. Motion to compel and for sanctions. The defence filed this motion on April 23rd, but it was ignored by the court until the recent May 7th hearing. Again, it took Judge Gull only 3 days to file the motion for contempt, to address the motion for contempt. And then, yeah, okay. Motion for Franks 3. The defence filed this motion on March 13th. Judge Gull has ignored this defence filing now for 62 days. Oh dear. Dear. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt. So she's not ruled on that. So she's not ruled on Franks 3. Well, she's got Franks 4 as well now. So we're 62 days and counting on that one. Ruling on the first Franks motion. Additionally, while it took Judge Gull over 4 months to rule on the first Franks motion, which was denied without hearing, it took Judge Gull 43 days to issue an order on the prosecution's request to find the defence attorneys in contempt. For what? That's 3 days, not 43 days. Oh dear, they need proofreaders. 3 days. All right. The prosecution's contempt motion is not relevant to the merits of the case, while the defence's various motions described above are relevant to the merits of the case. Yet Judge Gull acted on the prosecution's motion within 3 days. So I think we've got the gist of that. Many defense motions have resulted in Judge Gull issuing an order stating these 3 words: denied without hearing. I'm going to get a t-shirt printed. Deny without hearing. What are you looking for?
It's clothes.
Oh. Most of them are wet. Since their reinstatement alone, Judge Gull has denied defence motions without hearing a total of 8 times. It feels like more, including denying motions to compel discovery, which Mr. Allen needs to prepare his defence. Judge Gull's quick treatment of the prosecution's motions on matters auxiliary to the innocence or guilt of Richard Allen versus Judge Gull's treatment of defence motions that are related to the merits of the case provides a rational inference of bias for Judge Gull's bias for the prosecution and against the defence. Certainly, it appears that Judge Gull used the prosecution's motion for contempt as a vehicle to malign the defence while simultaneously ignoring matters raised by the defence that would malign the prosecution for its handling of discovery. This provides a rational inference of bias. I can't, I honestly, honest to God, cannot see how anybody can't see this. Surely you can see, everybody can see this. It's obvious. Obvious. Judge Gull ignored the defence request to set aside 2 weeks to present Mr. Allen's defence while refusing to set any time limit for the prosecution. Oh, Kyle always looks at me strange. He always looks at me strange. Did I without hearing with a picture of the seagull? Oh, I'm going to do it. All right. So, on or before, no, start again. On or about October 4th, 2023, Mr. Allen's counsel notified the court that they would need approximately 2 weeks to present his defence. In the aforementioned April 28th, 2024, Sunday morning email, Judge Gull, sua sponte, issued a stern message in the email indicating that the trial would end on May 31st, not more or less. So it was due to start on May the 13th with jury selection, which she was going to allow 3 days for. The trial proper was going to start on May the 16th, and then it was going to end on May the 31st. So if you hadn't finished by May 31st, that was it. You know, she just cut you off. And I don't know whether she was going to give the jury some kind of, you know, allocated time in which to come up with a verdict. Michelle, are you a member? Yes, you are, because you're in green, Misty. You are a member. All right. So, before issuing her order on the days allotted for trial, Judge Gull failed to reach out to the parties in order to determine how many witnesses were expected to testify, the expected length of their testimony, how many videos were expected to be played and the length of those videos, and most importantly, how long each side expected their case to last, based upon the evidence that they expected to present. Between all defence counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer. No, it's insane. I've never heard a judge like give them a finite time, like you've got to finish by this time. That's crazy to me. Judge Gull's inflexibility only impacts the defence, as the prosecution presents its case in chief first, and therefore likely would have enough time to put on its case, leaving the defence with little or no time to put on its case in chief. And then what about rebuttal? Like, they're allowed to rebut. So what if, like, Nick McClellan just ran down the entire time, and then the defence had no time to present a defence? The jury wouldn't know that they'd been told that they've got to finish by this date. It would just be, oh, that's it, that's all. I mean, come on. Come on. The jury wouldn't know, because all of this pre-trial stuff that, like, obviously we're aware of because we're following it. But a jury's not aware of it. By definition, they shouldn't know anything about it before the trial starts. Richard Allen possesses constitutional rights to the compulsory process of having witnesses testify on his behalf and to confront. Okay. And to confront witnesses pursuant to the 6th Amendment of the Constitution of the United States, as well as a right to present a complete defence pursuant to the 14th Amendment. When the defence asked Judge Gull on the May 7, 2024 hearing if the state of Indiana would be forced to abide by the same time constraints as the defence, Judge Gull would not commit to such a requirement of the prosecution. No, of course she wouldn't. Out of fear that the prosecution would run out the clock and leave the defence with minimum time to present its case, Judge Gull forced the defence to accept her remedy, a continuance of a speedy trial. Because of Judge Gull's refusal to guarantee the defence the same amount of time for trial as the prosecution, Richard Allen was, for all intents and purposes, denied his right to a speedy trial. Yeah, it was one or the other. She gave him an ultimatum, like she did in October. It was either, resign, recuse yourself, or I'm going to disqualify you in front of the world's cameras. That was what she did on October 19th. That was her plan. All the above circumstances create a rational inference of bias against the defence in favour of the prosecution. Judge Gull engaged in extrajudicial activities that raise a rational inference of bias, especially when Judge Gull may have to rule in how extrajudicial activities of a key state witness will impact the admissibility of Richard Allen's purported confessions. Okay. Judge Gull was appointed to preside over the case on November 4th, 2022. Since being appointed a special judge, this case has become one of the highest profile cases in recent memory, even receiving a worldwide attention. The victims of the murders are Abby Williams and Libby German. On July 9th, 2023, more than 8 months after being appointed to the case, Judge Gull chose to comment on a post concerning a softball tournament at the Abby and Libby Memorial Park. The post upon which Judge Gull commented stated what an honour it was for the girls to play in the Abby and Libby Memorial tournament. What? Did you say something?
No.
Oh. What a great honour it was that Abby and Libby's grandparents present our girls with their championship finalist ring. Okay. Judge Gull chose to comment on a post concerning a softball tournament. Post upon which Judge Gull commented. Judge Gull's comment was, "Congratulations." Okay. While seemingly innocuous, Judge Gull's choice to comment on a post involving a softball tournament celebrating the lives of the victims of the crimes in which Judge Gull is the presiding judge was inappropriate. I guess even if it wasn't, I guess it would seem that it could be. I don't think that's as big a deal as all the other stuff, though. That's my opinion. Certainly, when factoring in other issues raised in the first motion to have Judge Gull disqualified, as well as the issues raised in the second motion to disqualify, Judge Gull's comments were even more inappropriate, providing an appearance of bias against Richard Allen and in favour of the state of Indiana, who is prosecuting the accused murderer of the victims who were identified in the post. Yeah, it's got a bad look. The defence believes that Judge Gull's choice to comment on social media, as detailed herein, on its face supports a rational inference of bias, as well as an appearance of bias. I certainly do think it has an appearance of bias. However, as new discovery evidence adds another layer of conflict and bias to Judge Gull's post. Oh, God. God. I know. She has absolutely no worries. She just sails through. I think they're all in on it. I do, honestly. Okay, May 6, 2024, the state of Indiana filed its formal request for a pre-trial ruling on admissibility. Within said request, the state reference. Here we are. Here's the psychologist in question. Within said request, the state... Are you going out?
Yeah.
All right. See ya. He's gone out now, so he's not going to bug me anymore. He probably heard that. All right. Within said request, the state referenced Dr. Monica Waller as being a psychologist providing services to offenders at Westville. One of those inmates being Richard Allen. Subsequent to the filing of said pleading, members of the public began to discover evidence that Dr. Waller had joined and participated in social media forums, outlets, etc., involving the Delphi murders. Naturally, these facts were reported to the defence through various means. It's also true that the defence deposed Dr. Waller on Wednesday, May the 8th, at the law office of Hillis, Rosie and Dean. The deposition was not completed due to timing constraints and will likely be reset in early June, at which time the defence expects the depositions to conclude. The defence was unaware of the apparent social media activities of Dr. Waller at the time of the deposition, and therefore the matter was not addressed. It wasn't until shortly after the deposition concluded that those issues were brought to the attention of attorney Rosie, who conducted the deposition. Since May 8th, the defence has become aware of information that suggests Dr. Waller did in fact engage in social media activities relating to the Delphi murders. The defence is not in a position to determine the extent and nature of said activities at this juncture without conducting further discovery. However, the defence is aware that the online personality purporting to be Monica Waller, including a picture of Dr. Waller, appears to have been deleted or removed and or wiped clean any online presence related to the Delphi murders. Yeah, she just jumped out of a load of Facebook groups. This appears to have been done in the hours following the deposition referenced above. Again, this court is faced with a conundrum. The judge's decision to publicly comment on matters involving the death of two girls is evident that Judge Gull does not find it inappropriate to engage in such communications about a pending case. How then can Judge Gull be impartial in making any determinations on the defence motion to suppress a state's request for pre-trial ruling on admissibility or communications between Richard Allen and his state-appointed psychologist? If this court were to find that Dr. Waller's alleged acts were inappropriate, then by extension, the same could be true about Judge Gull's actions. Oh, dear. As the purported confessions loom as potentially the most powerful evidence against Richard Allen, any appearance of bias or conflict that exists for Judge Gull as she makes determinations of the legal impact of the witness's social media activity on those reported confessions provide a rational inference of bias. It's insane. It's just all insane. It really is. Yeah, if she's been threatened, why doesn't she just step down? Or has she been threatened that if she steps down, it's all going to be dead bad for her? Could be a threat like that. Additionally, even when Judge Gull rules against the defence and does not suppress the purported confessions, Judge Gull will likely face a second legal argument: the admissibility of any social media postings of this witness that includes the Delphi murders, in order to attack the witness's credibility. Should the prosecutor object, claiming that the witness's social media comments on the Delphi case are inadmissible, Judge Gull will once again find herself in a conflicted position due to her own social media comments concerning a post involving the victims of the murders. Oh, I see what they're doing here. That's clever. Judge Gull's starting position, apparently, is that it was appropriate for her to choose to comment on a social media post concerning the victim's softball tournament. Therefore, it would be more likely that Judge Gull's starting position will also be that this Dr. Waller's social media posts and activity are similarly appropriate. With this starting position, the defence will face a heightened burden in arguing for the inadmissibility of Dr. Waller's social media posts and activities. This additional hurdle, created at least in part by the court's inappropriate comments on social media, creates an inference of bias or prejudice against Richard Allen. Disqualification / recusal is the appropriate action in terms of remedying this prejudice. Oh, I like it. I like how that twisted and turned. I liked how they've done that. That's canny, that. Judge Gull has impaired Richard Allen's ability to defend himself by denying his reasonable request for expert and administrative staff funding. This is outrageous. This is outrageous. This is outrageous. This is outrageous that she's just denying them like money to pay their own defense. Like, Rosie. Has Rosie been paid yet? Has Rosie actually been paid yet? But like, she's denying them funds to pay for experts. Absolutely crazy. In 2023, the defence tendered bills for matters relating to their defence for Richard Allen, totaling over $38,000. That's not that expensive. Like, for a trial of this magnitude, for a murder trial, to defend it effectively, that is not an outrageous sum of money. Judge Gull has not authorised payment of those bills as of the date of this filing. Defence counsel has been forced to advance those experts out of their own pockets. For example, the defence has paid $26,000 for the work its investigator performed in the spring, summer and fall of 2023. See, look, they're paying for this out of their own pocket. They must truly believe in Richard Allen's innocence. How else, why else would they put their hands in their own pockets? Oh, I guess it's maybe their business's pockets to pay for Richard Allen's defence. They must truly, truly believe in his innocence. They've not only put their reputations on the line to defend him, to defend against Gull's treatment of them. They could have walked away in October and said, "Oh, I'm done. I'm gone. There's no way I want to be involved in this crap." But they didn't. And now they're paying for the experts they need out of their own pocket. They truly believe he's innocent. Like, they're not just doing their job here. They truly believe in him. That says a lot to me. Okay. When Judge Gull was not satisfied with the format of the investigator's bill, the defence tendered a new bill to meet the court's expectations. Because the investigator deserved to be paid for the work he performed, the defence paid the investigator out of its own law firm. After trying to rectify the issues Judge Gull had with the bill's format, Judge Gull failed to order the payment of such expenses associated with the defence's private investigator. Outrageous. The defence has sent multiple requests to Judge Gull and her staff, seeking input as to why this bill has not been paid. Judge Gull has not responded to these requests. The lack of response to these requests for payment creates a rational inference of bias. Exactly. Of course it does. Of course it does. Also, while the prosecution has unlimited access to funds and law enforcement experts, Judge Gull initially defied the defence request for expert funds for certain experts needed for the defence of Richard Allen. Only after the defence filed requests for reconsideration and apparent public outcry did Judge Gull change her mind and provide the defence funds for these experts. The refusal to initially provide funds to the defence for experts provides rational inference of bias. At least she changed her mind on that. At least she went back on that. That's good. Well, they shouldn't have had to argue, but at least that's something. Evidence that public confidence in Judge Gull has eroded due to continued improper conduct. Well, I can't see how anybody taking notice has not seen what she's up to. The thing is, most people don't take notice. I bet the majority of people in Indiana have no idea, even if they're aware of the Delphi case, have absolutely no idea what's going on. Like, you have to be really interested in the case to know what's going on. And I think that's probably how she's managed to get away with stuff in her career. I don't think this is the first time she's pulled stunts like this. It's the first time she's been confronted with it, though. Anyhow, that's my opinion. Evidence that the public confidence in Judge Gull has eroded beyond any form of, I don't know, recovery. Evidence of the erosions of the public confidence in Judge Gull can be shown through letters that Judge Gull has received, as well as letters the Indiana Supreme Court has received, as well as memes and others. I hope they show some memes in court. Oh dear. And other social media content that can easily be located on the internet. Right here, Francis, if you want to have a watch. Find attached 14 letters and emails that members of the public have taken the time to draft and then sent either directly to Judge Gull or to the Indiana Supreme Court. These letters and emails provide evidence that the public perception of Judge Gull's ability to be fair and impartial has eroded. I bet she hasn't even read the letters. She won't have read them. She will not have read them. All right. Multiple people paying attention to this case believe that an inference of bias and prejudice against the defense exists to such a degree that they took the time to alert this court and the Indiana Supreme Court what they are observing. Okay, so March 28th, Paige Moore wrote, Judge Gull, among other things, Mr. Allen was denied funds for expert witnesses, even though Americans are guaranteed a fair trial. Experts are needed for forced confessions and bullet markings. April 1st, Oscar Lopez wrote to Judge Gull saying, I have serious doubts that you, the judge presiding over this case, is capable of being fair and impartial. March 29th, Lisa Trick wrote to Judge Gull, you are the most biased judge I've ever seen. And you ought to be ashamed of yourself. This is not a fair trial. On March 27th, LGW wrote, it appears that the defense is being prohibited from being able to defend their client. March 28th, Stephanie Cope wrote, I have watched every phase this case has gone through and many others. It's shocking and disturbing seeing Mr. Allen and how his public defenders are treated so unjust. I can't understand the lack of self-awareness you have concerning your own biased feelings. March 29th, Hope Douglas wrote, in my opinion, it's clear as an outsider looking at this case, you have presented your rulings as biased, almost always pro-prosecution. The perception of common everyday citizens, i.e. objectively reasonable people, who have taken the time to voice their concerns about the apparent bias they are witnessing, should not be overlooked. It shouldn't. The good people of Indiana should not be overlooked. Judge Gull has refused to order the state to comply with discovery rules to the detriment of Richard Allen. The Indiana Code of Judicial Conduct 2.6 states that a judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Comment 1 states that the right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. Comment 2 discusses the important rule the judge plays in overseeing the settlements of disputes, indicating that the judge should be careful that efforts to further settlements of disputes do not undermine the party's right to be heard according to law, and that the judge should keep in mind the effect that the judge's participation in settled disputes may have, not only on the judge's own view of the case, but also on the perceptions of the lawyers and the parties if the case remain with the judge after set efforts are unsuccessful. Okay, judge shall hear and decide on matters assigned to the judge except when disqualification is required. Point 1 states that judges must be available to decide the matters that come before the court. So the defence incorporates paragraphs 1 through 134 in support of Judge Gull's violation of those ICJC to blah, blah, blah. Okay, Judge Gull has held only 2 hearings with current defence counsel since June 15th. That's insane. There's been only 2 hearings since June 15th. That's insane in a murder case. And 1/2 of the March 18th hearing pertained to the prosecution's hearing on contempt, unrelated to the merits of the case. Even though the defence has filed several motions seeking hearings on discovery matters that are deeply impacting the defence, Judge Gull has ignored the opportunity to assist in the resolution of these matters, either through a hearing or some other means. Judge Gull's refusal to act on discovery disputes raised by Richard Allen raises a rational inference of bias. Judge Gull has only allowed cameras in the courtroom once, at the hearing, that when she knew one way or another that she was kicking attorneys Rosie and Baldwin off the case. Rule 2.8b states that a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals with in an official capacity, and shall require similar conduct of lawyers, court staff, court officials, and others, blah, blah, blah. The defence incorporates paragraphs 1 through 138 in support of its contention that Judge Gull has violated Rule 2.8. Judge Gull has run one of the test courts for cameras in the courtroom and appears supportive of cameras in the courtroom. However, the only time in this case that Judge Gull has specifically allowed cameras in the courtroom was on October 19th, 2023. On that date, Judge Gull knew going into that hearing that she would either allow attorneys Baldwin and Rosie the opportunity to withdraw or proceed to a hearing in which she would read into the record a handwritten document she penned before the in-chambers hearing, disparaging and discrediting attorneys Baldwin and Rosie. Judge Gull's attempt to disparage the defence counsel with cameras in the courtroom, again, the only time cameras have been in the courtroom, violates Rule 2.8 in addition to all other facts pled herein. That's good. This is immense. This is immense. It would be difficult to believe that an objectively reasonable person would not believe that Judge Gull had demonstrated bias and prejudice against the defence. Her own words, grossly negligent, incompetent and sloppy, are proof of these obvious facts. Beyond Judge Gull's words lies her actions. They are articulated throughout the body of this motion. Actions often do speak louder than words. The actions of Judge Gull warrant her recusal and/or disqualification. The defence is requesting this court to restore public confidence by withdrawing from the case. The defence is requesting this court to disqualify itself to reduce the likelihood of costly appellant litigation and the cost of a retrial should a negative outcome against Richard Allen result from the trial, should she remain on the case. The cumulative effect of each piece of bias and prejudice recited herein supports the defence request for a change of judge. Richard Allen A man presumed innocent deserves a fair trial, as do the victims' families and the entire Delphi community. Judge Gull's continued involvement in the case will leave a cloud of doubt over legitimacy of the proceedings. It totally will. It totally will. Accompanying this motion is the affidavit of Richard Allen, which the defence requests be incorporated into this document. The same affidavit sets forth the facts establishing the timelines of defendant Allen's request for a change of judge pursuant to RCP 2.4. And finally, this motion is also accompanied by a certification that Richard Allen's attorneys believe in good faith the facts recited in the affidavit are true and accurate. So there goes. Richard Allen, I swear and affirm under penalty of perjury that the foregoing representations are true. Boom. Boom. So now we've read that, I'm going to do a quick cheeky poll. Quick cheeky poll. Okay. Do you think Judge Gull will recuse herself? Yes or no? We're going to do the poll for 5 minutes. Let's see what you think. Do you think she will? Not that she should, but do you think she will? Do you think she will? Will she stay or will she go? And we got through the whole thing. That's true. Many innocent people accept plea deals due to the fear of railroading for crimes they didn't commit. It's so sad. It's so sad. That's right. It was Labrato. William Labrato was interviewed, yeah. They sacrificed one girl and killed the other. Yeah, he did. That's exactly what he said. That's exactly what he said. It was very poignant. I thought that was very poignant. They sacrificed one girl and killed another. Jesse Snyder, yeah. I did a live stream including information about Jesse Snyder. The what was it called? The Good Old Boys? I can't remember now. I'm going to have a look. It was a while ago, wasn't it? Let's see if I can find it. There we go. The Good Old Boys of Delphi. Yeah, got Jesse Snyder in there. This one. Hold on. This one. The Good Old Boys of Delphi. There you go. So 6 months ago, if anybody wants to go and check it out who haven't seen it. The Good Old Boys of Delphi. Can I link it? I can link it. I'm going to have to do this. I can even pin it. I'll pin it to the chat, top of the chat. so people can go and watch that. She'll never recuse herself. I believe in the ordinance theory. I do. I have to say I do. I mean, I can't. I think the thing for me is, if what's in the PCA is the only stuff they've got against Richard Allen, then it's incredibly weak evidence. And that stands in its own right. And I was waiting to see what else the prosecution had against him. But when all this ordinance stuff came out, the more I've looked into it, the more convinced I've become that somewhere in that posse of losers are the real culprits. Now, whether that's Brad Holder, Patrick Westfall, and Elvis Fields, or whether that's other people connected to Ordinism that we don't even know about, I've become very convinced that there's something way bigger going on. And just the way that Richard Allen has been treated is another reason why I believe that there's something very dark and very, very nasty that's gone on. That the fact that he was being guarded by Ordinists in itself is crazy. In itself is absolutely crazy that happened. It's just, you can go down a massive rabbit hole and never come out if you think about, if you think about everything that's happened. Doug Carter's, the many tentacles. That keeps resonating in my brain. What did he mean by many tentacles? And then in the most recent filing, we've seen that an email from Doug Carter that's just been completely overlooked, between Doug Carter, the superintendent, the big boss of the Indiana State Police, and some senior official in the FBI, who believed that Brad Holder was a suspect, and yet he was just let go, like no investigation, didn't even appear to, extract the data from his phone, tells me that he is being protected. At least he is being protected. I thought, look, when Richard Allen was arrested, I thought, good, they've got him. Thankfully, finally. And yeah, the PCA looks flimsy. If the bullet's all they've got, it does look flimsy. But it's only when you really, really look at it, that you think, this dude surely is innocent. He has to be. He has to be. I do remain on the fence, though, because, it's I don't know what else the prosecution might have. I think is there something genuine that pins Richard Allen to that scene? Is there something they have that pins him to that scene? And it doesn't look like there is. His phone doesn't pin him there. There's no DNA. There's no fingerprints. The only thing that pins him to that scene is an unspent casing that is supposedly from his gun. And that has no chain of custody. So that in itself should not be reliable evidence. The chain of custody of that bullet was lost. So even that doesn't pin him to that scene. And where you have so much evidence that's way stronger against other people who had the motive and who had the means to conduct that murder, it makes me look at Richard Allen and think, you poor bastard, you have been set up. You have been set up, and your life and the lives of your family utterly destroyed. And that's the way I keep going. That's the way I'm looking at this case now. Anyway, I'm going to close this poll. Let's have a look here. End poll. Let's have a look at the results. The results of the poll. I've got to scroll all the way down here. All right, so do you think Judge Gull will accuse herself? So we've had 151 votes. No, she's not going to recuse herself, 89%. And then yes, 10%. That doesn't add up to 100. How's that poll scientific? Where's the 1% gone? We've got 1% floating in the ether. But yeah, okay, so 10% think she will. Well, I hope you're right. You 10%, which I want to say should be 11%. Anyhow, you 10%, I do hope you're right. I sincerely hope you're right. The math's not mathing. It's totally not mathing, is it? YouTube. Go back to school. Learn a bit of basic addition. It's not the face of a guilty man. No. It's so sad. It's just so sad. It's so sad. 1% not answered. No, it doesn't give you an option not to answer. Like it only calculates your vote if you click yes or no. I think she would have to be forced out. The 1% was Gull nicking it. Did someone vote for both? You can't vote for both. You can't vote for both. It's a forced choice. Yes or no. Once you click one or the other, then your vote counts. You can't vote again. How can it be proven how long that one piece of circumstantial evidence the bullet was there? That's it. The way that you could prove how long it was there is if you've got a proper chain of custody. So you've got a photograph of it in the ground, a photograph of it being taken out of the ground, a photograph of it in transit, and but you don't know if it was planted there. Now, people have talked about, and I did a video on it a while ago, about the fact that it was brass. And was it in relation to this case? Was it in relation to another? Oh, no, it wasn't in relation to this case. No, it wasn't in relation to this case. It was in relation to the knife sheath in the Koberger case. And the clasp of the knife sheath is brass, and it will degrade DNA. That's what I'm thinking of. It doesn't take into account the lacquer though on the brass. But no, I mean, you could probably get some kind of specialist to look at the the condition of the metal that casing was like whatever that casing was made of, there'll be an approximate measurement that can be made as to how long it's likely to have been in the ground based on the type of metal it is, and like, you know, the type of erosion that would happen. But that is probably contested science, so there probably wouldn't be one definitive way to say how long that bullet had been in the ground. But I don't know. I think the best way to deal with that evidence is to get a really good expert who's willing to testify that unspent casings, like the markings on an unspent casing, the science is more contested than it is with a fired bullet. Like the markings on something that's actually been fired through a gun, rather than being ejected from a gun. So I think that's the way they'd have to go. Anyhow, I'm going to go now. Been on here 2 hours. So I'm going to go now. Glad we got through the whole 40 pages. But there's loads of filings coming out that I rely on people like criminality to read to me. Yeah, cycled and ejected. So if it's been ejected, then the markings on it are not as certain to have come from a particular weapon than if it's actually been fired through the weapon. Not that I'm an expert, but that's what I can glean. So, all right, guys. Thank you all for joining me. Thanks once again for sitting through one of these, you know, epic readings. And thanks as always to the mods who keep you all in line. Not that anyone was kicking off tonight, I don't think. And thanks for the donations. Very much appreciated. And I'll be back tomorrow. Not with Delphi, but probably with Sebastian Rogers, I would imagine. But I don't know. Something else might kick off, come along. And we'll wait and see. Wait and see what tomorrow brings. So enjoy the rest of your day or your evening. And I'll see you then. Bye, guys.